All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 31st, 13th, 2024. It says 31st. We are going to work off of voting list number 11. It does.
I got a letter from Delegate Holmes that he was withdrawing the bill for some reason. I can't remember what the letter said, but my reaction was, okay, well, that's the end of that. I think it's a good bill. So we could pass it and send it over to the House, but the House cross file is not going to pass. I don't know. Probably not. Let's hold it. I'll get my staff to call his office and ask what's going on.
All right, just so we're announcing, we're going to hold Senate Bill 479. And then we'll do it here. All right, we're going to go with Senate Bill 134.
Senate Bill 134 establishes the Correctional Ombudsman Unit in the Office of the Attorney General and specifies the duties of the unit. There is an amendment in your packet. It's number 503229/1. So with the amendment, instead of being housed in the Office of the Attorney General, the Correctional Ombudsman would be part of a new independent unit in the executive branch. And the existing Juvenile Justice Monitoring Unit, which currently is housed in OAG, would also be moved over into this new independent statewide unit. And there is also one other amendment in your packet from Senator Carter. That's number 553624/1. This just deals with the membership of the Correctional Ombudsman Advisory Board, which provides advice to the Correctional Ombudsman. It simply specifies that the board has to include representation for individuals with experience in mental health care and substance abuse treatment.
All right, just real quick. So there are two amendments. Can you describe the first? You describe the first amendment. You describe Senator Carter's amendment. So I'd like to. Can you just? The first amendment is. Correct me if I'm wrong. 503229/1. Okay, just one more time from the top.
So that amendment 503229 moves the Correctional Ombudsman out of the Office of the Attorney General and instead creates a new independent statewide entity, which would house the Correctional Ombudsman and the Juvenile Justice Monitoring Unit, which is being moved from OAG into this new independent unit with the amendment.
All right, so we know we all discussed this several times. You saw an amendment on the floor today, which is going to provide the budget language for this. So I'd like to move this amendment. All right, second, everyone okay? All right. Now we'll take up Senator Carter's amendment, which is 553624/1. One more time.
So as part of the bill, a Correctional Ombudsman Advisory Board is created to give advice and guidance to the Correctional Ombudsman. Currently, the membership has to reflect people with certain experiences. So the amendment here would simply add to that criteria that the board should have representation from individuals with experience in mental health care and substance abuse treatment.
I'd like to move Senator Carter's amendment. All right, sorry. Now the bill's before you is amended. Now, can you speak? I know we're still working on the Department of Juvenile Services had some language that they'd like us to consider. And can you put Josh on?
There might be a couple of technical fixes in the language just to make sure that the Department of Juvenile Services is only covered by the Juvenile Justice Monitoring Unit and not both them and the Ombudsman. So I think that will be forthcoming as a floor amendment, but the intention is just to clarify that the Juvenile Justice Monitoring Unit has the authority over DJS facilities and the Ombudsman has the authority over the Department of Public Safety and Correctional Services, their facilities.
Which is the intent of the bill. So my recommendation is that we could move this bill and have the floor amendment on, but that floor amendment, since you know what it'll be, would be considered to be friendly, but you all heard it. All right, so then the motion's for
The amendment that Josh just said about the clarification with juvenile services, that is going to be a floor amendment? Okay.
we will work in consultation with the Department of Juvenile Services to make sure that it is crystal clear and tight. And it'll be a floor amendment that we're going to prepare for the floor. So now the bill is before you with the two amendments. The motion's for favorable.
Second.
Okay, is everyone okay being recorded in the affirmative? All right, Senate. Would you like to be sure, Senator West would like to be a sponsor. Senator Carter would like to be a sponsor. I'd like to be a sponsor. Senator Wallstreicher would like to be a sponsor. Senator Sidnor would like to be a sponsor. Senator Charles would like to be a sponsor. All right.
Just make sure I've got everyone. So Chairman, Senator West, Senator Carter, Senator Wallstreicher, Senator Sidnor, and Senator Charles.
Got it. All right. Senate Bill 134 with amendments passes unanimously.
Senate Bill 319 repeals the requirement for the Maryland State Commission on Criminal Sentencing Policy to report to the Governor and General Assembly by October 1st, 2024, and each October thereafter on the number of charges, convictions, and sentences for violations of 4203 of the criminal law article, which pertains to wearing, carrying, or transporting a handgun, and 5133D of the public safety article, which pertains to restrictions on the possession of regulated firearms. Instead, it requires the Department of State Police by October 1st, 2024, and each October thereafter to report that same information. There is one amendment in your voting packet, that is Amendment SB 319-993-822/1. That's Amendment 993-822/1. And it strikes the requirement that that information be compiled by the Department of State Police and substitutes the Maryland Judiciary.
Senator West.
Yes, on this one, Judge Morrissey came to my office and said he's going to do me a favor. And I said, I wonder what that is. And he said, we have that information. The state police doesn't. We'll be happy to provide it. So that's why we have the amendment, and it puts the reporting requirement where it should be with the organization that has the information, namely the judiciary. So with that, I move favorably on the bill.
Excellent. No, I think it's great. Just to address the fiscal concerns, does this does that address that? Because the judiciary has the information.
Say there may cost. He said we have the information, we can provide it easily.
No, that's what I want to say, because initially it wasn't going with them, it was going with what state.
Yes,
police, so,
that's right. That was the problem. The state police said it was going to be very expensive because they didn't have the information, but the judiciary has the information, so there should be no cost.
Excellent. So I'd like to move the amendment. Excellent. Now the bill's before you as amended. The motion's for favorable with amendment. Seconded. Is everyone okay being recorded in the affirmative? Senate 319 with amendment passes unanimously. We're gonna go to seven. So the next, this is 729, and then we're gonna go to 488. So 729 is next. Never mind. We'll give folks a little extra time here. All right, Shamari, are you ready with Senate Bill 488? Okay.
Yes.
Are you ready for 488? All right.
Senate Bill 488 prohibits a firearm industry member from knowingly creating, maintaining, or contributing to the harm to the public through the sale, manufacture, distribution, importation, or marketing of a firearm-related product by engaging in conduct that is unlawful or unreasonable under the totality of the circumstances. It requires a firearm industry member to establish and implement reasonable controls regarding the sale, manufacture, distribution, importation, marketing, possession, and use of the firearm industry members' firearm-related products, and establishes that a violation of these provisions is a public nuisance. In addition, the bill authorized the Attorney General to bring an action against a firearm industry member for a public nuisance caused by a violation of the bill's provisions as specified. And two, a person who sustained an injury or loss as a result of a violation of the bill's provisions to bring an action for damages against a firearm industry member as specified. The bill's provisions are severable. The bill takes effect June 1st, 2024. Previously, the committee adopted amendments 343-328/1, which is in your packet. And so I believe the committee would need to reconsider that vote.
Okay, so just procedurally. So we're gonna, can you explain, just explain what the amendments did? And then we're gonna I guess we'll strip the bill of the amendments, and then there are a set of another amendments that are coming in. So based on the deal mainly with the trace data and information, so.
So
that's-
the amendment that was adopted struck the private cause of action from the bill and added a requirement for firearm industry members to report certain information about trace requests to the Attorney General.
All right, so the motion is to strip that amendment.
Second.
All right, it's been seconded. So is everyone okay with that? Well, here's, so there's another amendment coming.
This amendment was the amendment that took out the private right of action.
This is gonna put this back in.
It's gonna put it back
It
in.
is.
Okay, fine.
So trust, so is everyone okay? Is everyone okay with stripping the amendment? All right, now the bill is original before you. Now, Shamari, there's another amendment. Can you please read the next amendment?
And so Amendment 843121/1 was just added to your packet. You don't have a reprint, but that amendment still removes the private cause of action. It takes out the trace request reporting requirement under the public safety article and instead creates a study. And that's an uncodified language in Section 3. At the bottom of the amendment page, it states the Attorney General, in consultation with the Department of State Police, shall study and make recommendations regarding the legality and feasibility of a statutory requirement that would compel licensed firearm dealers within the state to provide records of firearm trace requests received from the Bureau of Alcohol, Tobacco, Firearms, and Explosives to the Attorney General. The Attorney General shall provide staff for this study. On or before June 30th, 2025, the Attorney General shall report to the General Assembly in accordance with Section 2-1257 of the State Government Article on its recommendations and findings.
Okay, so in the intervening, what, now 20 hours since you were here. So both the Attorney General and the state police have been consulted and have agreed to this language. So I'd like to move the amendment. All right, is everyone okay adopting the amendment? All right, the amendment's adopted. And now, you want to do a roll call on the amendment, or? I was gonna say now the bill's before you for discussion, so we can.
Well, I would just say. It's fine, it's fine.
All right, so we'll, the amendment, now the bill's before you as amended, open for discussion.
For Shamari, I guess.
Yep.
Shamari, by removing the language that was taken out from the amendment that was put in yesterday, does it satisfy? Is there a part, does any of that deal with the PLACA predicate exception?
And so the PLACA predicate exception is based on, if you look on page.
Which one, where are we at? we on
So
the-
the reprint from it has a reprint of the bill, but that's because we don't have the other
This
reprint.
could be
I'm just working
confusing,
from
yeah,
that.
so just, okay. It is,
Page.
so just, if you look at the reprint, okay, it's gonna be a reprint of an amendment that we stripped, so just, when you reference that, just make sure the whole language is not, that's not the bill, you're actually looking at this before you. But you can reference a section in the
Yeah.
original bill.
So in the original bill, it's 3-2302. A firearm industry member may not knowingly create, maintain, or contribute to harm to the public through the sale, manufacture, distribution, importation, or marketing of a firearm-related product by engaging in conduct that is unlawful or unreasonable. That would be the predicate exception that this bill seeks to create.
So it does stick to the knowing violation language?
Yes.
And does it talk about the proximate cause?
It does not add any language for proximate cause to the bill, but that would still be required proof in any tort action.
Well, if it's required proof in tort action, why don't we have it in here to replicate the same language as PLACA?
That would be, I think it's assumed just based on tort law.
Well, Shamari,
If you
we
want an
all know
amendment,
what happens when one's assumed, especially in matters of attorneys with letters of the law.
if you want an amendment, we could get that drafted to add it.
I would like to have that amendment that talks about the violation with the proximate cause for which the harm of the harm for which the relief is sought. Language
So-
added in there, which would be consistent with what PLACA requires.
So I don't think that's necessary, although I appreciate the intent. So as Shamari indicated, it's not, I mean, it's not assumed, it's part of any tort case, right? So you have a duty, a breach, a causation and damages. Those are the elements of any tort, not any tort, every tort. And so you have to be able to prove the causation in order to prove the case. And we don't, for every tort, we don't add causation language that's inherent in the tort system. And so, so that's not necessary here.
Then why would it be added into PLACA in the first place if it was in every tort? Because we went, and with all due respect, Senator, yesterday we pushed an amendment through without understanding what was happening and that it was, I even read it into the record, that it was contrary to current law. And you spoke against it. And then in PLACA, it specifically, Congress enacted specifically in PLACA that and they added the language that, and the violation was a proximate cause of the harm for which the relief is sought. There is a reason they added that specific language in there, and we should never assume when we're dealing with people that have the tendency to make lawsuits based on an emotional response, not based in fact. This requires a basis of fact. That language, it requires it. So I would urge this body to adopt this simple language, which creates the proper sequencing and justification for any movement by the AG against the firearm manufacturers. It's not that big of an ask. I think it's consistent with law, and it should be consistent in our law. We can tighten as a state restriction, but we can't loosen them, and we're loosening this. That is not how it's supposed to work.
So I appreciate what you're saying. We didn't take the stuff out from yesterday because we thought it was contrary to law. We took it out because it was logistically challenging.
Oh.
And so we switched to the study,
Well,
which I think is
I would say it's
a fair approach to this. So I don't think the Attorney General is going to take an emotional view of the lawsuits. They are obligated under our statute and their own ethics to bring to bring cases that they are able to prove by the standard of evidence. And so I don't see any reason why we would depart from the traditional standard here, separate from any other tort standard that we use throughout the law. So I appreciate what you're saying, but there's no reason to depart here. It's no different than any other tort. That's the whole concept behind the bill.
Mr. Chair, I find it very concerning that we're going to say that we know better than something that's been in place and enacted by Congress with specific language for specific reasons. And we're going to go ahead and drift away from it. So with that, I don't want to continue to debate this, but I do want to press my amendment request because I think it's worthy. And I would request the roll call on it. It's unacceptable to go outside what's already in written federal law.
All right, so can you just explain the amendment that you're
Yes,
proffering?
the amendment would be that with Shamari, the part about that we add the language that requires that the violation was a proximate cause of the harm for which the relief is sought. That's it.
All right, there's an amendment before you. Any further action need to be taken by member? So it's been seconded. You'd like a roll call?
Yes, sir.
No on the amendment.
No.
I'm gonna pass for now.
No. Yes.
Yes. Senator Charles.
No.
Senator Kelly. Oh, no, thank you.
Yes.
Senator Carter, no. Senator Smith.
No on the amendment. Oh, you have to go with West first, go.
Senator West.
Expanding my vote, it sounds like we're being redundant. I have never had a problem with redundancy, so I'll vote yes.
What's the vote?
1, 2, 4. 7 to 4. Yeas 4. Nay 7.
The amendment fails 7-4. But so Shamari, then I'll just ask you, so Senator Fulton brings a good point up, but is it in your opinion, I understand it's always our intent. Is it necessary? Was an amendment necessary in your opinion?
In my opinion, I don't think it is necessary. Like I said, with any tort action, you're gonna have to prove causation as an element of the claim.
Well, following up on that, here's where I'm stuck about whether this bill has some language that undermines the need for, undermines the idea of proximate cause and necessitates us being more explicit. I don't understand. I don't know what version I'm looking at, but I believe it's under something called 3-2302. And it says a firearm industry member may not knowingly, I get that, create, maintain, and then or contribute to harm to the public through the sale of, manufacture, and so on. My understanding of, proximate cause and this concept of contribute to harm, I don't understand how you square those. So what is this term contribute, and how does it play into proximate cause under this bill?
So I think generally in tort law, there can be multiple proximate causes or multiple causes of a harm. And so I think that's just saying if the firearm industry members' conduct through creating, maintaining, or contributing to the harm, I think that would allow the Attorney General under this bill to still file a public nuisance action.
Is contribute to the harm the same thing as the proximate cause of the harm?
I think that's just, that language is just there to show that they may not be the sole proximate cause. And so it allows, if there's multiple causes, then, and if the right required elements can be proven in the claim against the firearm industry member, then the Attorney General will be able to make that claim.
So I'm just trying to make sure I understand your answer. You're saying that contribute to the harm is the same thing as proximate cause?
So I don't think it's the same thing. I think it's just providing an alternate means of alternate theories, I guess, of the claim that the Attorney General might file. If there's other tortfeasors involved, then the firearm industry member doesn't have to be the sole proximate cause.
Right. So need a little bit more time to look, to discuss. I'm gonna go, I'm just gonna see if Senator Folden would like to jump in, but I want to make sure James is done with her line of questioning first.
No, I'm trying to read. Thank
Okay.
you. I'm sorry.
No, we'll come back.
I sort of said I was studying.
Okay, we'll come right back. Senator Folden.
So, Shamari, I want to ask you, much like the chairman did, he spoke about by not having it in there, consistent with what is in federal law. My question to you is, would adding that amendment and the language in that amendment have changed anything in this bill as written?
I don't think it would change anything.
So it would just close any potential loopholes that could be misconstrued, but it doesn't change anything in the bill by adding in that language that we just voted down.
I think it might be superfluous, but I don't think it would change anything. Generally, unless there's something explicit about, being a strict liability action or something, then
So,
under tort law, it would be just proximate causation. And
so it would have made it a tighter, a more appropriate fitting language then, is what you just said. It would not have left any ambiguity.
I think that would perhaps take away some ambiguity, yes.
So it was a favorable, for the purposes of this bill, it should have been seen as a favorable amendment to decrease any ambiguity, in your opinion, as the writer.
I know you can't opine on the in the intent, but you could give us a legal analysis of what the practical implications would be one way or another, but I know that council can't comment on.
But you asked him to comment from your perspective on
No,
it.
I said, is it necessary or is it prophylactic? I asked the same thing you did.
Yeah,
does
but
it
I
change anything?
asked it from the opposite, the other side, which said, does it decrease any ambiguity? So it makes it more proper and fitting to the purpose of the bill, according to the sponsor. So why would we not have taken that as a favorable amendment? We're talking about matters of law. Well, I'm asking, I don't care, Mr. Chairman, I don't care who answers. We're talking about matters of law. We want to have less ambiguity. It doesn't matter who it is, doesn't matter what side you're on. We don't want ambiguity. We always want to have clearly definitive expectations and requirements in law. The less if there's ambiguity, it creates problems and opportunities to create more problems, unintended consequences, as we always talk about. We always hear this word. And now here we are, just shooting down a measure that by our own council's bill drafting expertise is that it would have taken away the ambiguity and eliminated ambiguity and was not a bad amendment to move forward. So I would like to know why we want to all of a sudden on this specific measure, this body that works so hard to make sure there's no ambiguity and that we're not indicting or arresting the wrong person for the wrong offenses or charging them with erroneous charges on this measure, wants to take back and make it so ambiguous to allow for that. That's just baffling to me.
The reason why I voted against it, because council's advice was also that it was superfluous and not necessary.
But council just said that it would have made it less ambiguous and made it better. In my opinion, by what he said, it can be superfluous, but it made the language stronger. It made the bill better. That's what we're supposed to do as legislators. Make strong bills, make them have purpose, and stick to the design and intent of the bill.
So I know, I understand, Senator. I appreciate it. We have debated that amendment and then voted it down. 7-4.
I understand, but had you not asked a follow-up question to kind of throw it back in our laps, I would not have had to ask the follow-up question to show that it is necessary.
I understand.
And I think it's been proven. So
Well, thank you
we're
very
just
much.
gonna,
No, I get it. I appreciate it.
Mhm.
All right. Further discussion? All right, I'd like to make a motion for a favorable with amendment. It's been seconded. Do you want to do a roll call?
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
Pass.
Senator Muse,
Yes.
Senator Folden,
Unequivocally, no. Bill.
Senator James,
I would like to support a bill that I know would comply with PLACA, and I know that this committee is capable of doing that. But unfortunately, this bill is too unclear and ambiguous for me to understand whether we've done that or not. But I know that it would be very simple to draft a bill that would comply with it. So for that reason, I'm gonna vote no.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Appreciate some of the moving and some of the stuff that's been redacted, but it's still a bad bill. No.
Senator Carter,
After much contemplation, yes.
Senator West,
Let me explain my vote. I would be entirely pleased to see the Attorney General go against some gun shop, which is providing a regular stream of weapons to drug gangs in Baltimore City, which find themselves on the streets of Baltimore. I'm concerned that the Attorney General, who through his constant press releases seems to be doing everything he can to stop people from having guns in various ways. I'm concerned that he would use this authority to go against not just that gun shop, which I think should be shut down, the one in my hypothetical example, but others as well that are operating legally. And so for that reason, I'm going to vote no.
Chairman Smith,
Yes. Favorable with amendment 7-4. We're now going to move on to Senator Carter. With Senate Bill 729.
Senate Bill 729 establishes that a healthcare related physical intervention as defined by the bill that was reported as an adverse event to the Maryland Department of Health does not constitute use of force or a use of force incident that a licensed security guard or security guard agency must report to an employer or to the Secretary of State Police respectively. The bill takes effect June 1st, 2024, except that the effective date of Chapter 763 of 2023 is amended. The bill takes effect on the taking effect of Chapter 763. There is one amendment in your voting packet. The amendment strikes provisions of the bill as drafted. And let me just read the amendment number to you. It is for Senate Bill 729, amendment number 963-529/1. That's 963-529/1. The amendment strikes provisions of the bill, and on page 3 of 3 of the reprint, instead provides that the employer of a security guard providing security guard services on the premises of a healthcare facility is defined in 19-114 of the Health General article shall submit quarterly reports to the Secretary of State Police on the number of code greens initiated for combative persons and code purples initiated for security only responses, as those emergency codes are identified in Title 10 of the Code of Maryland Regulations occurring in the previous quarter. Additionally, the bill alters the effective date of Chapter 763, which provided for reporting of use of force incidents of security guards. That effective date is changed from its current effective date of June 1st, 2024 to instead be January 1st, 2025. A conforming change is made that the provisions of the act that I just mentioned would go into effect January 1st, 2025 as well.
So the amendments take the entirety of the provisions to 2025? Or just part?
Right. So that's my read of it, except as provided in section 3. Yeah, it looks like everything goes into effect 2025, although the bill itself goes into effect June 1st, 2024.
Okay.
But it is interesting drafting if I'm reading it right, and I think I am. The bill goes into effect
2024, but nothing
Right.
under the bill is in effect to
Correct.
2025. That is interesting, right?
But right, so just to simplify the language, if it's a code green or a code purple, and it's a healthcare facility, those would be quarterly reports as opposed to individual reports. The current law, and you can see on page 3 of the reprint, provides that a licensed security guard agency or security guard employer shall, in accordance with paragraph 2 under current law, report any use of force by a security guard while providing security guard services on its behalf or for it to the Secretary of State Police within 48 hours after receiving the form completed under B1 of this section. So they have 48 hours per event now. Now it just turns those into quarterly reports for the healthcare facilities.
Just real quick, I'm gonna get to Senator Golden. Does everyone have, I didn't have this in my packet. Does everyone have this in their packet? Just make sure everyone has it. Yeah, because I didn't have it. Okay. Okay. You guys are smarter than I am. All right. All right, let's go Senator Folden and then Senator Sidnor, then Senator West.
Waited a long time to hear those words, Mr. Chairman. Smarter than you are to figure out where the paper was. So my question is, I understand the intent of the bill, so I'm not trying to dispute that part, right? We're trying to facilitate a smooth process. The problem I see with this bill is that when you go to quarterly versus individual reporting, there is a loss of specificity. All right. And we lose that by a quarterly report versus reporting it right away. Because I guess, what about actions that end up resulting in someone getting seriously hurt? Do we still wait for quarterly to report it? That the person got seriously hurt by restraints? Because my concern is, in these situations, we have at times not the most trained security in physical restraints. We have not the most trained people, but the people that we have trained, and we train them specifically in use of force, they are required to report it immediately, in or out of the hospital. or 40, but it's immediate, but it has to be to the state police within 48 hours. They have to report it immediately to their police agency. Under MPAA, a law enforcement official is required on any use of force to report that incident immediately.
Check, Senator, on the applicability, the law enforcement official. I'm not 100% sure.
No, I'm just making a
right.
point.
Okay.
I'm making a point, counsel.
Gotcha.
My point is that we require the ones that are trained in use of force tactics and restraints to report it immediately, but the ones that don't receive that type of training and are more likely potentially to cause harm directly to someone because they get a little over aggressive and cause injury, we're saying you don't have to worry about that. We can do that in a quarterly report. Like, I think that is counterintuitive to what we've been trying to do in the areas of use of force, especially with those that are predominantly, when I read this and I read the article, you're talking about potentially people that are suffering from mental crises or in some type of act or some type of influence that is causing them to react that would require medication potentially by a doctor to sedate them, to calm them down. So I think this is changing the whole idea of what we're trying to do here and we're trying to look at measures individually. We should be looking at these individually. How can we improve? That's one. And then it specifically in this amendment, it specifically talks about, I think, code green, right? Is code green and code purple, is that somewhere in the law? Because I'm just asking, because what if they decide, you know what, we don't want to comply with this, we'll just change these to code reds?
The amendment language does cross-reference to Title 10 of the Code of Maryland Regulations, although I couldn't provide that to you right now.
But I guess my question is, does code green and code purple, is there some language somewhere to tell me exactly
Right.
what that is?
So, sorry, I'll just clarify that.
Yeah, no.
If you look at the amendment language,
Yep.
it states that if you go down to the third line from the bottom, after the comma, it provides that as those emergency codes are identified in Title 10 of the Code of
For
Maryland
combative
Regulations.
and security only responses. Gotcha. So we have security only responses are purple, but we have combative responses that are where they would have a use of force, potentially more so, a code green.
I think for you, Senator, to
I just, like I said, I understand the intent of the bill but I think loosening the reporting requirements in a use of force is not the direction that we should be going. So thank you.
A real simple question on page 2, lines 23 through 25. Why is that language deleted?
So under the bill as it was drafted, the language beginning in line 22, just so I'm sure we're on page 2, line 22. So that language that is non-bolded text is the existing language in the law, or from the bill that was passed last year. So it provides that use of force does not include the mere presence, verbal commands, or escorting an individual with minimal resistance. The language that's stricken after that is bolded text, which means that it was the language that was being added by the bill as it was introduced.
Right. So again, the question is, I guess the language was included because that type of physical intervention was not to be included in the definition of use of force. So if it's being removed, is there an implication that would be deemed a use of force?
Well, I mean, if I'm understanding the question correctly, my read of the bill and the language that was being added is that by adding or a healthcare related physical intervention that was reported as an adverse event to the Maryland Department of Health. You would be exempting the the 48-hour reporting to the Secretary of State Police by deeming that if something had been reported as an adverse event to MDH, you don't also have to make that report to the Secretary.
Okay, thank you.
Thank you, Mr. Chair. When I first heard this bill, I guess I'm directing this to the sponsor of the bill. My impression was that this bill related to healthcare facilities and guards who are going to be restraining people or administering drugs in healthcare facilities. Is that the case, or did I get it wrong?
Related to healthcare facilities. That's what the intent is.
Where's that limitation in the bill?
In the bill language or in the amendment language?
Well, in the bill as amended, where is there a limitation, there's a statement that this only applies to healthcare facilities?
Right. So if you turn to bill page 3 or page 3 of 3 of the reprint, you'll see the bulk of the requirement as it exists to the existing language as well as what's being changed with the amendment. What the bill is saying is, if you look at subsection C, that's the general requirement for the 48-hour reporting on use of force incidents. Then in let's see, subsection D, which is the underlined new language, it provides that an employer of a security guard providing security guard services on the premises of a healthcare facility, and that's the special requirement for them.
All right, so D applies to healthcare facilities, but C applies to any facility.
It's a general requirement, right? Although, as you mentioned it, Senator, it probably does need an additional conforming amendment to provide that in subsection C1 have an except as provided in subsection D to make it clear that that D is the exception.
Okay, so here's my concern. Healthcare facilities are well familiar with complying with laws and making reports. They do it all the time. There's a lot of paperwork involved with running a healthcare facility. But someone who just has a store and wants to, during the Christmas season, hire a security guard is not used to this kind of stuff. And this has reporting requirements associated with it. I don't want to, unless there's a mandatory reason why it's necessary, put state regulatory reporting requirements on the back of every single small business person who decides for a brief period of time to employ a security guard, like during the holiday season. So maybe the sponsor could answer whether or not that was their intention, that be part of this bill, or wasn't your intention only really to apply to healthcare facilities?
This bill, thank you, Senator. This bill is specifically to carve out an exception for security guards that work for healthcare facilities. Last year, we passed a law that required security guards that carry firearms to have the same training as law enforcement officers to carry security guards. Carry firearms. The hospitals noted to me really at the end of last session that they felt they should be exempted because their security guards undergo already even more expansive training. And they also pointed out that these incidents in their lives are daily, multiple times, sometimes daily, because of the nature of the work and the patients. And so they wanted to have an exemption from the reporting requirement as everyone else. And so that was what the impetus for the bill was. So this bill before us today is only to encompass healthcare facilities. It is not to encompass anyone else. If anyone else ought to already be covered under the existing law.
All right, I get it. Thank you.
All right, I'd like to adopt the amendment and work off of that for further discussion. Is your motion to adopt the amendments seconded? All right, is everyone okay with that? All right, further discussion.
Make sure that it's specifically for that. We can do that, right?
Sure, I mean. Yeah, the technical suggestion would be is if the committee intends to make it clear that subsection C1, which is the general reporting requirement, only applies or excuse me, doesn't apply. Let me rephrase that. The D is an exception to the general reporting requirement. I think you probably need an exception clause in C and probably B.
What else makes sense? What else makes sense for reporting? Quarterly, they don't want to do. What else makes sense?
Look, I didn't want to belabor this because I heard you say about the training, but when you're talking about they have expansive training, I don't know how, are you talking about firearms or are you talking about use of force? Because use of force is really, and compliance measures and being able to use compliance techniques for pain. You can inflict pain on someone for compliance. These are actual strategies that are taught, whether it's, I mean, and I don't know what their use of force curriculum and how much they get would be consistent with that. But I can tell you that when you're utilizing the use of force should only be commensurate to the amount of force or resistance provided, right? It should be directly. So there are times that if you have people that are untrained that are going to initiate the contact, initiate the force, and they're going to seek this compliance. And my concern is that we may have people that are potentially a little overzealous, maybe put somebody in a wrist lock or do something, an arm bar, and all of a sudden now we're causing injuries, especially if it's like the care facilities you're talking about, because now we're talking about predominantly a lot of either people in mental crises or older, who have more frail bodies. So I just don't want to see us do something that kind of waters it down to where we're not reporting it within a time frame that's accurate or not accurate, but timely. Because, okay, is 48 hours too tight for that? Maybe, I don't know. I mean, but I would say that we don't want to do it every quarterly because then we're losing that the importance of the specifics of the circumstances that they need to get retrained on. So, I mean, do you make it 5 business days for them? I mean, if for this specific group, I mean,
From the hospitals, and I want to stress that last year we passed a bill because I strongly believed that these persons in these positions of power and that are able to use force should have really strong training and that they should have strong reporting requirements. But what the hospitals represented to me and to us in the bill hearing is that their security officers already have extensive training, and under HIPAA, they are trained in use of force, patient care, de-escalation and other things beyond even what a normal security guard is trained in. I cannot tell you specifically because I don't know, but that's what they have indicated. They said it's in the law already.
I would love to see their training because the reality is you're putting people in a position of authority with a lot of power, and that you need to be accountable for that. And when we have, I mean, I'm just telling you from what I've seen at some of the hospitals that I've seen with the security going, what would, in my opinion, be a little bit over the top. And we need to make sure that the training is not, I don't know how robust this training is. I would like to see it. Like, are they going hands-on? Are they teaching them about what actual pain compliance is by having them do it on other people? Because in the law enforcement realm of things, we have to be exposed to it. We do it on each other in the academy because you want to know which one works and which one is the most uncomfortable, because that's probably going to be your one that gives you the best, opportunity to diffuse a volatile situation. De-escalation is important. Are they doing it online?
I
Like,
agree with you.
are they doing it online at nighttime while they're sitting there and kind of watching it? Or are they doing hands-on? There's a difference. That's all I'm saying. There is a
Oh,
difference.
I agree.
Yeah. So, I mean, I would be curious what their
So is
training
there, in terms of the reporting requirement, is there a suggestion? Did you have a proposal to like
I
a
mean,
middle ground?
If they're 24 hours a day, which I'm assuming these security guards are 24 hours a day, just make it like within 7 days, just 1 week. Because that gives them time, but it's still close enough proximal to the incident that there's accountability. What we don't want to do is give a quarterly one. Then these guys writing these reports are like, well, I got till 3 months. We just reported. I don't have to do this report right now. And then
Senator Fulton, I feel like we've reversed roles here. I agree with you.
Look, I just think that it should be sooner. I'm fine with 48 hours, but if you agree that a quarterly is too long, but I would still like it to be close to the proximately speaking to the incident that caused the use of force.
So is there,
7 days? Or do you want to keep 48 hours? I mean, I was okay with 48 hours. You're telling me that they don't like the reporting requirement within 48 hours. So.
a weekly report? Like we report all the incidents of the week in one report. That makes sense.
All right. There is a motion to make it weekly, 7 days, 7 business days,
Within 7 days. No, it's weekly because there's 24 hours.
7 calendar.
within 7 calendar days.
Second.
All right, so motion's been seconded. Do we need a roll call, or is everyone okay? All right. Successfully adopted. Now the bill's before you as amended. Further discussion. Motion's for favorable. It's been seconded. Is everyone okay being reported in the affirmative? All right. Senate Bill 729 passes with amendments unanimously. All right, Senate Bill 174.
So give me 1 second. Senate Bill 174 extends from 60 to 120 days, the period during which the holder of a commercial driver's license may be out of compliance with the child support order before the Child Support Administration is authorized to notify the Motor Vehicle Administration to begin the process to suspend the obligor's license. The bill also alters child support agency procedures must take before notifying MVA of an obligor's noncompliance, including reporting CSA to petition the court to make a finding after a hearing that suspension is appropriate as specified. It permits the obligor to make a request for reinstatement of the license with CSA or the court. It requires CSA on the request of the obligor to request for MVA to expunge an obligor's record of license suspension for failure to pay child support as specified. And it prohibits the CSA from using a randomized lottery system to select obligors for the purpose of notification to MVA. There is an amendment in your packet. That amendment was already adopted by this committee. That was amendments number 103924. And what that amendment did was it deletes the provision about a randomized lottery. Oh, I'm sorry, that's not what that does. It strikes the requirements that the administration prove by clear and convincing evidence that the obligor has funds to pay arrearage and has chosen to withhold the funds or is voluntarily impoverished, and that the Child Support Administration has exhausted all available collection and enforcement mechanisms. And it instead just requires that the administration prove that the obligor is 120 days out of compliance. And it also alters the factors that an obligor must prove by preponderance of the evidence to prevent a suspension.
Let's move the amendment so we can work off of the amended bill. So I'm sorry,
It's already-
sorry, that's already
already
adopted.
adopted.
My apologies. All right. Further discussion on the amendment. The bill as amended.
Sponsor and it's a bad bill. Other than that, let's go. Second.
All right, there's a motion for favorable. It's been seconded. Is everyone okay with the amendment? Is everyone okay being reported in the affirmative? All right. Senate Bill 174 with amendment passes unanimously. All right, let's go back real quick. We forgot to adopt a technical amendment to the past bill. Jamie, can you explain what we forgot to adopt?
So if you go to page 3 of the reprint.
Just the bill number as well, please.
Oh, sorry, it's 729. So on page 3 of the reprint in subsection C, this is the section that provides for the security guard agency or employer to provide the 48-hour reporting. To make sure that D is clear as an exception to that requirement, you would add in line 4 after numeric 1 for C. Add except as provided in subsection D, and then it would continue with the language that's there. It would say a licensed security guard agency or security guard employer shall, in accordance with paragraphs 2 and 3, report any use of force by a security guard while providing a security guard services on its behalf, et cetera.
Is everyone okay adopting it? All right. Everyone's okay? All right, I'm gonna continue, keep the same vote as before. Yeah. All right, unanimous. All right, excellent. All right. Senate Bill 118, that's Jamie. I'll give you a second here, but I want to move on that next. Let's give you 1 second.
Senate Bill 118 authorizes a person to file a petition for expungement if the person received probation before judgment for driving while under the influence or driving while impaired. The petition would need to be filed at least 10 years after the date the petitioner was discharged from probation. The bill also authorizes these individuals to petition to shield a police or court record for these dispositions 5 years after the person was discharged from probation for the offense. The committee has previously adopted amendments on this bill. Those are in your voting packet. And I will read you the bill number. You know what? I apologize. I think you have the wrong amendments and
Got it. I see it. I have it right here. Is it the right one?
well, you actually adopted slightly different amendments the last time. Sure.
Amendment 393-824/1.
So this is one of the amendments that was adopted, right?
Yes, and then you adopted language that moved the effective date from October to July.
Correct.
And then Oh, that's it.
I think there was added language that you have attached there, Sandy.
Oh, just kidding. Just language.
Right,
Yeah,
so
sorry, guys.
that language change was adopted. So the committee had previously adopted and saying, sure, that would be great. Thank you. The committee had previously adopted Senator Walt Stryker's amendment, which is before you in the voting packet, but had also adopted language that would have changed 10105E4 to provide that petition based on an entry of probation before judgment for a violation of 21902A or B, so the alcohol offenses, would not be entitled to expungement if within 15 years after the entry of probation before judgment, the person had been convicted of a crime other than a minor traffic violation or a crime where an act on which the conviction is based is no longer a crime, or received probation before judgment for a violation of 21902 of the transportation article. There's also a conforming change.
All right,
that
I'm
was
gonna
adopted.
do this. I think we're gonna I'm gonna call voting for today because it's 5 o'clock. This is gonna be, so I want to just make sure we have an interlineated copy for this with it, which is collapsed and consolidated because there are a lot of moving parts here and it's an important bill to vote on. So we're gonna when we come back, we'll start with that bill. And then Senator Sidnor, we're gonna go to your bill, number 2. Yeah.
All of the amendments in this amendment packet.
We'll have a tight amendment package tomorrow. So we'll make sure everything's squared away, set up so people can actually understand what's happening. So won't be too many moving pieces and you'll have time to study this. We do have to do Senate Bill 1145. What?
I have the vote sheet back.
Yeah.
Sorry.
And that'll be the last bill today. So
Thank you.
for your bill, we got the approval. We're just gonna collapse everything. It'll be the first thing we move on tomorrow and then. Yes, yes, we do. Yeah. All right, so last bill today, it's 1145, Senate Bill 1145.
Have received in your voting packet was actually a consolidated amendment that I had prepared after the last voting session where the committee had adopted amendments. So that was just to show the committee what it had already done, but unfortunately there was a mistake and it wasn't in there.
Senate Bill 1145 prohibits a child who has been convicted or adjudicated delinquent of rape or a sexual offense that if committed by an adult would constitute a felony from in-person attendance at a public school or non-public school that receives state funds. Each local school system must provide alternative educational options for affected students that align with existing law governing the schooling of children who are registered on the Adult Sex Offender Registry. The committee, it's Senator Folden is already on, Senator McKay is on, and Senator West is already on. There is an amendment in the packet that's number 563-923/1. So essentially what this does, it kind of corrects a gap that's in the bill. So the bill applies to all sexual offenses that if committed by an adult would be a felony, which is first-degree rape, second-degree rape, and third-degree sex offense. There's another statute that creates what are called reportable offenses, which are essentially offenses which, if a juvenile is arrested for them, the local school system that the juvenile attends would have to be informed of the arrest and the subsequent disposition of the case. That list does not include third-degree sex offense. So there's a risk that the schools are not necessarily informed of an arrest and a disposition for a third-degree sex offense, even though it would be a felony if committed by an adult. So what the amendment does is add third-degree sex offense to the list of reportable offenses.
So floor, and then whenever we get off, we're gonna vote after floor. I mean, I think folks, I'd like to start, doing the round robin meetings to go over the remainder of the list, so folks just are acclimated with the material, and if people have questions, we can start working things out before we get to the voting session. So let's take, I will reach out to you all to set up a little rotation so we can all meet and kind of talk about the bills that you want on the list, that are on the list. Sift through that, and then we'll vote at probably an hour and a half after floor, so that folks have an opportunity to get something to eat, and then also meet and look over the material. But if you could, with some extra time here on this end, and in the morning, just look over the list, and if there are other bills that are not on the list that you want on the list that are close to ready, let's start that conversation now. All right, so yep.
How do we know what's possible?
Come talk to me.
Just ask, right?
Yeah, just get come.
Petition. Shall we petition?
Yeah.
Is there a projection of like a couple days out at all, or is it pretty much just?
No, that's why, I mean, we had this great rhythm going,
Yeah.
Earlier, but with the truncated schedule and us getting on the floor so much, it's kind of died. So I'd like to, tomorrow we'll start that up again, meet with everyone.
Yeah.
And then we can get, for the last 2 or 3 voting sessions, we'll have a vision. Yeah, absolutely.
Individually.
Yeah.
So at some point, we get a date out committee hearing.
So that day is called, but also, all right, hold on, before you all check out. So we're gaveling out. What?
Thank you.